Welcome to Just Theory Season 2. In this episode, we are speaking with Karen McAuliffe, Professor of Law and Language at the University of Birmingham, whose principal area of research focuses on the relationship between law, language, and translation in the EU legal order. We talk about the structure of judicial decision-making in EU courts, as well as all that is lost and found in the translation of judicial opinions. So, without further ado, I now present you Episode 1 on things lost and found in legal translation.
Hi, Karen. Thank you so much for joining us. We are delighted to have you on our podcast today. We would like to begin this podcast by asking you a few questions about your career path. Was it a straightforward legal career, or had any other inspirations played an important role in getting where you are today?
Thank you. First of all, thank you so much for the invite to be here and chat with you today. It is great. It's really an honor, and I know we're going to have fun. I hope we're going to have fun in the next hour or so. I had to laugh there when you were asking that question, because I doubt very much if anybody's path is straightforward to where they end up at any particular part.
It seemed to be a consistent theme across all our speakers, that they would had quite a turbulent way to get where they are, and I think this is characteristic of any reflective person whom we hoping to invite to this.
I think so. Yeah.
Place.
I found, so when I thought about this, obviously you told me in advance that you'd be asking this question. So when I thought about it, I thought, God, it's a series of like happy, or in some cases not so happy, accidents that have led to various things happening then that have led me to be here today. But also, when you look back at a pathway to a space, you can either view it as this sort of series of adventures that led you somewhere that's completely unplanned. But I found that, like, when I look back on it, there's a definite thread, whether that was conscious or subconsciously planned on my part, that has led me here. So it was really interesting. So basically, when I was applying to universities, I really enjoyed languages at school, and I studied French and Spanish. In Ireland, we also do Irish, obviously, till the age of 18. So I wanted to do something to do with French, really liked French, didn't really know what I wanted to do. And I went to Belfast for a weekend to see family. And when I was there, I went and had a look at the campus, and Queen's University Belfast had a swimming pool. And at that time, this is the mid-90s, and at that time, I'm from the Republic of Ireland, and there were no real universities in Ireland that had facilities of any kind, except perhaps the University of Limerick, where you could go and study sports science. And of course, they had a swimming pool for those students. And so I was like, oh my gosh, this place has a swimming pool. I could leave home. It would be so exciting. And that, I just fixated on that. And I thought, I'll get a prospectus and I'll find a degree that has something in French. And so literally that's what I did. I flicked through this prospectus and I was like, I could do engineering in French or physics in French. And one of the programs was common and civil law with French. So it was like a dual degree. And I had a few years previously done some work experience. I'd been going through a phase of wanting to be a journalist. And a friend of my mother's, Kathy Sheridan, she's a journalist with the Irish Times. And I idolized her. I still do. She's very cool. I thought she was just great. And she had made this throwaway remark one time saying, oh yeah, if you want to be a journalist, study law. If you want to do anything, study law. Law will open up loads of doors for you. So I had this prospectus. They had a course, a common and civil law of French, and I had Kathy Sheridan's words ringing in my ears.
Did they mention the swimming pool in the prospectus?
Of course they did. Yeah, that was the key thing. And so yeah, I applied for this common and civil law with French, and then I forgot all about it. I went off to France. I worked as an au pair. I didn't actually get into Queen's on the first round. I had to wait a couple of days later. It wasn't called clearing then, but effectively, you know, that's how I got in, got onto the program. And then, like, you know, had a great time at university. So I studied at Queen's in Belfast, and then also the Catholic University of Leuven has a campus in a place called Louvain-la-Neuve in just outside Brussels, and so I did part of the degree there. And throughout the degree, the only thing I knew for sure was that I didn't want to practice law. I found sort of black letter law very boring.
That's a common thread too. Almost every single guest so far said, "Oh yeah, as soon as I realized what law actually was, I was like."
Well, I guess just theory title for this podcast explains it all.
Yeah,
just we only invite theorists.
So yeah, so I had no interest in practicing law, but I didn't know what else there was to do. And to be honest, you know, I had never been exposed to something like academia as a career. You know, when I was at university, to me, the professors, they were just teachers. They were just like your secondary school teachers, only a bit cleverer, or, you know, happened to be at university. And it wasn't something back then, you know, the sort of exposure to all the different types of things you could do with your life wasn't something that we did very well in the Republic of Ireland in the sort of early 1990s. And so, yeah, so I really didn't know what I wanted to do. And after I graduated, I came across an advert for what's called a competition, a concours. The European Court of Justice was looking for lawyer linguists, and they were running a competition. And basically it was a translation exam. I thought, oh yeah, I've heard of that place, and that sounds exciting. And I sat the exam, and obviously I did well enough in it. I got called for an interview, and I ended up getting a job as a lawyer linguist in Luxembourg. And then this is a real pivotal point, I think, for me. You know, I had studied European law, so in theory I should have known A, that the court was in Luxembourg, and B, you know, what it was exactly, but I'd never really given any thought to the reality of how judgments are produced. I don't know, I just had this image in my mind of a bunch of judges sitting down and writing judgments, and the kind of huge machinery that goes into, you know, these big EU institutions, just lost on me. So I found myself in Luxembourg. I remember at the time my dad came with me my first day of work when I moved over to Luxembourg, because I couldn't really explain what the job was, because I didn't really understand it myself. And my mum and dad, I don't think they believed I had a job, you know. So I can remember Dad came with me. It was Valentine's Day. It was the 14th of February, and it was a very surreal time, but it was lovely. Also had a lovely, nice long weekend with my dad in Luxembourg. So I started working there, and I was very quickly fascinated by this mechanism, you know, this sort of what was going on behind the scenes, and by the fact that law wasn't this platonic sort of thing that existed, but it was
isolated, ever perfect,
was
an
actually
ideal state,
something that was created by people, and in the context of the Court of Justice, by, you know, people from so many different cultures and backgrounds were coming together to create this jurisprudence or case law, whatever you want to call it. And so I very, very quickly became far more interested in thinking about what I was doing than actually doing it. You know, so my job was really to translate judgments and orders and various things into English, mainly from French. But I was far more interested in sort of figuring out what was going on behind the scenes than in doing the job. And so after a period there, I decided I wanted to do a PhD. And And then again, you had this other sort of happy twist of fate. I was going to do a PhD on about how the court functions, the sort of behind the scenes stuff. And initially I wanted to do it with Professor John Usher, who was based at Edinburgh at the time. But I wasn't in a position to do a PhD unless I had full funding. And so I just applied to lots of different places, and I ended up getting really great funding to go back to Queen's in Belfast. And I think that was another really happy accident, because I ended up in what's called the Institute of Governance, and my PhD supervisor there was a political scientist, Robert Harmson. And you know, he really was a huge mentor, is still a huge mentor to me, and has shaped my career, you know, really in a great way. But even doing the PhD, I really never intended to stay in academia. I don't know what I wanted to do, but I was like, oh, I'll do this for a while. And then in the PhD, those PhD years, I got very sick. I had tumors on my liver. I had to take some time away, had some treatment, had some surgery. It all obviously went well. And again, that at that point, I was like, do you know, I really just want to be an academic. I really enjoy this. I love the research. I like engaging with students. I mean, there's aspects of it I don't like, as there is with every job. But from then on, really, I was kind of certain that I was in the right place. I ended up, my first academic job then was with John Usher, who ended up being the external examiner for my PhD. And then he gave me my first job at the University of Exeter's campus in Cornwall, which was nice. And then, yeah, here I am. Still
Amazing.
That's not to say I'll stay forever.
Yeah. Amazing. And you know, I had a little chuckle when I was reading through the papers that you sent through, because you warned us that you are not. No, not for that reason. Because when we were exchanging emails, he said, "Oh, you know, I'm not really a pure theoretician." And then I come across this. Language has a significant impact on the development of any legal order, as law is an overwhelmingly linguistic construct. Law is created, interpreted, and applied through language. And I just looked at I texted Emilia, and I was like, what do you mean this is not a theoretician? It would be very interesting, I think, to learn more about your project and what it is that you do, and why you decided to pursue that specific project, because it's very unique.
The project on the court, you mean?
Yes.
Yeah. So I've done my PhD looked at translation of judgments at the Court of Justice and the people behind those translations, and then I kind of stayed in that field, looking at sort of translation of multilingual law quite a bit. And then in 2012 I got funding from the European Research Council to do this very big project that looked at the Court of Justice, and the project was called Law and Language at the European Court of Justice. And the main reason I wanted to look at that was in the field of European law, you know, there's an obsession with a narrative that talks about how the Court of Justice has created what is in effect constitutional type law. And that's like an accepted narrative, which interestingly is being discussed by legal historians recently, who've shown that the push didn't necessarily come from the court itself, but came from European legal elites in member states. But that's a discussion for another day. But you know, there's this narrative that the Court of Justice, you know, has created this legal order, which it has. And so the judgments of the court that have created this legal order are very important, and lawyers and political scientists tend to like obsess over what the court is saying in these judgments. And lawyers tend to be looking at the substance of what's in the judgment. What is the court saying about the law, and how is the law developing as a result of what the court is saying in these judgments? And political scientists they are often very interested in why the court might be doing something, like what the motives of the court may or may not be in going one way or another in a judgment. But nobody's looking at how these judgments are created, because they're not. When I was this naive graduate in my early 20s and I went off to the Court of Justice, and I thought the judges all just sat down and wrote these judgments and handed them down. That is not how it works. There is a huge machinery happening behind the scenes that results in these judgments being delivered by the court. So obviously you've got your judges, you've got the people who work for the judges, the referendaires, the legal clerks. They've got teams of secretaries. There's a whole registry. There's an enormous translation directorate. The Court of Justice, in theory, functions or delivers judgments in 24 languages. It's 24 EU official languages. It's huge. And I had a sort of coming from studies from anthropology that had looked at the European Commission and Parliament in the early 90s, and had looked at who the people in these institutions were, and problematized what was going on there in terms of the institution having to speak with one voice, but being made up of all of these different cultures. People speaking different languages and coming from different educational backgrounds. And no one had really looked at the court like that, because there's this sense that, well, it's law and it's just being handed down by the court, and that it was very difficult for people to get access to the court. And so, yeah, I was really interested then in getting access and in sort of seeing what was going on behind the scenes, and understanding who these people were, and where they came from, these people who are creating these multilingual case law. And it's very interesting because, there's so many steps in the process of producing a judgment. And really at no point in the process is anyone sitting down with a blank sheet of paper. It's very formulaic, because it's so big now. There's a whole lot of templates that happen as the file moves through the various stages of the process. And I wanted to choose language as a lens through which to understand what was going on behind the scenes, because as you've read there now, law is made up of language, and well, any human endeavor at all is articulated and expressed through language, whether that's spoken, written, or another form of language. That is how humans express what we are trying to do. And then at the Court of Justice, on top of that, you have this issue of translation. And the translation is very interesting because it happens, there's a visible translation or overt translation that about, that you see, that happens at very specific points in the process. So when a question, for example, comes to the Court of Justice in Greek, from a Greek court, for example, that question is translated into French, because French is the internal working language of the court. So there's a very clear point of translation there. And then in theory, it's worked on in the court in French, and then the judgment is delivered in Greek, or the authentic version of the judgment is delivered in Greek. So there's another very clear point of translation in the process. But there's an awful lot of hidden translation that goes on, because as that document, or as the various bits of the file move through the stages, the process of production at the court, you've got lots of different people engaging with them. So that the question will get, excuse me, sent, reformulated in a way that allows the court to look at it. It'll get assigned to a particular judge rapporteur who works with his or her referendaire, who will be from varying backgrounds and have varying linguistic skills. They'll all work in French, But if they happen to be Greek, for example, they might want to go back and look at the Greek the original question in Greek. Or there's a pivot translation, you know, if something comes in Lithuanian, it gets translated into French and English becomes a pivot language. And so there's just lots of layers of translation going on as you work your way through the court. And so I was just really interested in learning more about that process and understanding who the people were, what they were doing, and how that might impact the final product at the end of it. And I think it does. You know, I think the judgments are shaped by the language in which they're articulated. That's the case in any court.
We talk in legal philosophy a lot about the courts,
Mm-hmm.
and we never really think about, like, we ever talk about the courts or a judge specifically. I think your scholarship in that respect is super unique. At least, you know, from our discussions before the episode, before the recording, we're talking about with Emilia about how, in a way, nobody's really taking that perspective, that this is and almost, I don't want to describe it as a production line, but in a way it looks like it works like a mini state or a mini corporation producing the outcome that is then, you know, further interpreted by many. But I see Emilia's eyes have a burning desire to ask a question.
Well,
sure.
my burning desire to ask the question was actually burning from the beginning as you were talking about your project. And I couldn't wait when you touch upon research methodology, because I have never seen, or well, maybe I very rarely see a scholar as rigorous as you when it comes to methodology. And I couldn't resist. I've been to research training, just introduction to research training for postgraduate students before recording this interview. And I'm sorry, I could not resist but to bring your chapter as a prime example of rigorous application of semi-structured interviews and other research methods that is done throughout. What was amazing about your piece was that the research is present, or research methodology is present throughout the paper. It's not something that you just highlight at the beginning, that's my methodology, and then I get on with this. There is a very, very clear commitment to rigorous methodology. Can I ask, where does it come from, and how important it is for you to conduct research that is so wonderfully aligned with methodological approaches and methods that normally some scholars would ignore? They would just offer an opinion and wouldn't even place themselves anywhere on a research methodology spectrum.
Well, thank you very much for that. That is very nice things to say about the research, and I'm really delighted that has come across, because rigor in research is something I feel very strongly about. Why it's come about is partly because when I set out to be an academic in this field of law and language, it's a newish field, you know, it's developing, and unfortunately there can be work in the field that has the potential to be really transformative, but the researchers fall down on the rigor of their methodology. And so from a sort of very I don't know how you term it, like a sort of broadly, I'm concerned with fields being considered robust and, you know, not being dismissed as like law and kittens, right? You know, I really feel strongly that this field of law and language is really important, and where you get research that isn't rigorous enough, a field, especially one that is newish or is developing, can be, you know, can never develop its full potential. So So that's kind of one of the whys that I'm interested. But also, I guess I don't feel that I can come to conclusions on the basis of my opinion. You know, I'm not a journalist. I didn't end up being a journalist. And I feel that sometimes needs to be the distinction between academic research and some, you know, there are some wonderful journalistic research projects that we see every day. But yeah, it's my opinion in the sense that it's a conclusion that I've drawn, but it's drawn on the basis of what I feel is quite rigorous research. And so the piece that you're talking about is the piece about the Advocates General, is it?
Yes, that's the
yeah.
one. Yeah.
And so in that piece in particular, I was asked to, so it's in a very exciting book that was published this year, which is about new ways of researching the European Court of Justice. All of them are empirical, and there's some wonderful chapters in that book. And initially I was asked to write about using linguistic research, like corpus linguistics methods, to look at the judgments of the Court of Justice. And I said, I can't do that because that doesn't really tell me anything. I do use corpus linguistics methods, but it doesn't really tell me anything about what's happening at the court, and you can't come to any conclusions on the basis of a corpus linguistics analysis of judgments of the court alone. You also need to go and talk to the people and ask them why they're making these decisions. What are they doing? Why do they choose this particular language? Who's writing the pieces? And in that paper, one of the most interesting things we were able to demonstrate in that paper was that Advocates General at the Court of Justice are not sitting down and writing those opinions individually, which is the impression we get. And again, it's this accepted narrative in EU law that the opinion of the Advocate General is his or her opinion. Now it is, insofar as the Advocate Generals are involved in drafting the opinions, they sign off on them, and it is their opinion at the end of the day, the opinion of an individual person. But they're writing them in teams. And so there are a lot of contributors to those opinions who remain invisible. And I think that was one of the most interesting things that we were able to show in that paper. I'm not sure if that answers your question.
Yeah, that answers my question. But obviously, Aleksandra is cannot wait to ask questions as well.
No, I was just going to add that it's an interesting perspective, because it seems to me that it's a very institutional perspective on different bodies within government, that a position of a judge is more of a judge as an institution rather than a judge as a person, which should come without saying, but it doesn't necessarily, if that makes sense. So when we're talking about judicial opinions, or when we're talking about AG's opinions, I think we do tend to, or you do see papers that simplify and flatten the landscape. So rather than treating the court as an institution, there's this tendency to treat it almost as a persona. Mm-hmm. So it's interesting to go in a different direction.
It's interesting that's a really interesting way of looking at it, because the Court of Justice in Luxembourg in particular, it has been presented almost as a persona at different periods. And you talk about the activist period of the court in the 1960s, and there's this presentation of it as a persona. But actually, the Court of Justice, or any of those international courts at all, they're less likely to have a real persona, simply because of the flow of judges in and out.
Could you actually tell us a little bit more about the structure of this, just for the purpose of our students, maybe who are not familiar with who Advocate General is and what's the role of the Advocate General, and how the structure looks like, just to illuminate the listeners.
Sure, no problem.
They are not familiar with the European law and the structure of the court.
Sure. So the Court of Justice is effectively the sort of Supreme Court of the European Union. There's two courts. You have the European Court of Justice, and then what's called the General Court. And I'll just leave the General Court to one side For now, they basically have different jurisdictions, and cases heard in the General Court can be appealed to the European Court of Justice. So the European Court of Justice has a judge for each member state. So there's 27 judges, one for each member state, and each of them have their own what's called a cabinet, like a chamber made up of référendaires, which are their lawyers who work for the judge, and their job is to assist the judge in drafting judgments and other things. And then obviously, you know, secretaries, etc. They work for the judge. And then in addition to that, you have advocates general. Lots of reasons for having advocates general. So it's a role that's borrowed from French administrative law, and the Court of Justice doesn't deliver any dissenting opinions. So you just get one judgment in a case, and that judgment is necessarily going to be a collegiate document. Deliberations are secret, so you might have a chamber of 5 judges sitting in a case, and the judgment that finally comes out from the court is signed by the judges. It's written by one of them, who is given the role of judge rapporteur, but it is the voice of the court, and there's no dissenting opinions, so they have to have come to an agreement on everything. And as a result, you can often find that judgments of the court don't have very thorough reasoning, or, you know, they often just deliver the judgment that here's the conclusion, and this is it. So partly to sort of work alongside that, you have these advocate generals who are, you know, they're similar to the judges, but they don't sit on cases, they don't sit in on deliberations, and they don't have a role in deciding what the judgment will be. And the role of the advocate general is to produce what's called an opinion. So that's the individual opinion of the advocate general in question about how a case should be decided. And the judges, in theory, the judge rapporteur is not supposed to start drafting the draft judgment until the advocate general's opinion has been heard. Now, opinions are not given in every case. So it used to be the case that they were, but the workload just got crazy. And so I think it was the Nice Treaty that introduced, you know, a curb on how many cases will have to have an advocate general's opinion. So you don't get them in every case. You tend to get them in sort of the bigger cases that are asking more constitutional type questions. If a member state has sent a question or is party to a case, they can request that an advocate general's opinion be given, but they're not given in every case. An advocate general's opinion are very important because in terms of EU scholarship, EU law scholarship, because the judgments are not very forthcoming in understanding where these decisions or why decisions have been made. The academic advocates general's opinions tended historically to be written more like these academic style documents, and so for EU scholars, they're the place to go to find out, you know, maybe what direction the law might take in the future, or the critique of the law, or
I think this is also the most controversial element of their role, that they actually have potentially or can influence the development of the law. And in a structure such as a supranational structure as European Court that has to act within confines of powers vested upon them, and generally that the European law must only operate within the competences vested upon them. So if we allow for a space to develop the law beyond certain competences, or maybe not beyond competences, but develop the law, that could be perceived by some jurisdictions. Poland is a prime example here with the controversy around the courts now, where creativity within the court that could potentially come from the opinions of the advocate generals can be seen as controversial, overstepping perhaps the boundaries, but in opinions of some. But this is the tricky element, I suppose, of the role of the advocates generals.
So is it like effectively a double translation? because, and I don't mean that translation in the direct sense. So if you would have a case commentary, for example, in the UK Supreme Court issues their judgment, and then you would have multiple case commentaries. Is the role of an AG effectively provide a binding case commentary, or is it more like equivalent to a judge drafting a dissent?
Persuasive. Oh, sorry.
Or is it more persuasive? Yeah.
It's first of all, they're not binding. Advocate General's opinions are not binding, and I think this is the trick, Emilia, that kind of gets them off the hook a little bit in terms of what you're saying, is because it is the opinion of that one person. It's not binding. They can talk about anything they want, and they are not implicating the court in any way, or they're not confirming that the court is going to go in one direction or another. Their job is to sort of give an opinion as to how they think this particular case should be decided, and the court has to take account of that opinion. The court has to listen to the opinion, doesn't have to follow it. So they're not binding. They can take the place of, a sort of a dissenting opinion or in a way, but in fact, I don't think the role of the Advocate General sits well if we have a framework from the common law system, because it just doesn't perform the same function. So the official function of the opinion is to guide the court in coming to its judgment in a particular case. Now, the real impact of the opinion can be to sort of give an indication of where EU law will develop, because if you look at any of the big constitutional type principles of EU law that have been developed by the Court of Justice, you see them first in Advocate General's opinions, so a year or two previously, so there is this sense that opinions of Advocates Generals can sound out how a concept might be received by member states. There's a lot of work in political science about why member state courts continue to engage in this process with the Court of Justice, at all. And the Advocate General's opinion is very important there as well, because it's kind of like a soft launch of a concept. See how it goes down, and the court will see what kind of reaction certain things are getting in Advocate General's opinions, how whether or not that actually plays a part in the court going one way or another remains to be seen. And then there are judgments where the court will cite chunks from an Advocate General's opinion directly. So Advocate General Jacobs had a huge influence on the development of competition law in the EU, because a lot of his opinions were followed directly in the judgments that they were in the cases in which they were delivered. And the other thing that Advocate Generals can do is be almost like a sparring partner for the court. So the court in a Court of Justice in a case before it can only look at the arguments raised by the parties. So the court doesn't have jurisdiction to sort of go off and talk about, if you're thinking of the UK common law system, and Lord Denning talking about bluebells blooming in the wood, the court can't go and do that. The court can't.
I suppose Lord Denning is a bad example, because he didn't follow didn't act within any confines of power vested upon him or separation of powers. But
yeah, and so the court can only look at the issues that are raised in the case before it, but the Advocate General can talk about whatever he or she would like to. And so that means that there are certain issues, certain concepts in EU law that the Advocate General can raise over and over again. And because they're raised in the Advocate General's opinion, and the court has to take account of the Advocate General's opinion, it forces the court to engage with those questions. So a good example of this, for students who are just coming to EU law, is the notion of horizontal direct effect of directives. So I can hear the groans of every second year law student now.
Not just the second year. I'm getting flashbacks. I'm getting traumatic flashbacks to my undergrad right now.
So that keeps coming up. The court keeps refusing to introduce horizontal direct effective directives, even though effectively, there are so many ways of circumventing the fact that that's not allowed, that you do effectively have horizontal direct effective directives. But because the Advocate Generals bring it up, the court then has to engage with it, and the court then will have to justify why it's not bringing it up. So it's a check on the court to make sure that the court is accountable, and that EU law continues to develop along a well-reasoned path, I suppose.
But interestingly, as your research shows, the Advocate's general opinion is not necessarily a homogeneous product of their own input, but is an effect of, or is produced by complex processes, which you describe and which are capable of incorporating or reproducing some side effects, so to say, that we are not very much aware of if we don't look at the internal working of the translation. So just to get back to your actual contribution and your work on translation, can you kind of elaborate a little bit more how your project helps us understand the role of Advocate Generals and the role of production of the opinions and judgments, and how they differ from one another in production through the process of translation, why language is important here?
Yeah. So as I've said, like, language is important anyway. And there's language will have an impact on the production of judgments in any court. Because there's always going to be an institutional language and a way of doing things, and a formulaic use of language in any sort of institutional writing situation. But that would be very difficult to study in a rigorous way in a monolingual court. But once you bring in the element of translation, all of the sort of impact of translation, or you can very easily see the impact of language when you've got two or more languages at play, because you can see where there are divergences and you can follow those divergences through. So that was one of the main reasons for looking at language. And secondly, it's just that nowhere in the literature on the Court of Justice, or not nowhere, but it's very rare in the literature of the Court of Justice for scholars to look at the court as a multicultural, multilingual institution, which it is. It's huge, and it's got people working there from 27 member states. Well, a lot of the British citizens are still there now with new citizenship as well. So you've got people working from a huge array of jurisdictions and coming together in a sort of a melting pot scenario to produce these judgments.
I suppose that ties in with your concept of translation as a third space.
The translation as a third space, yeah.
I know this is a separate paper, but I think there is a connection here that language translation has life and existence of its special kind and a special role to play in communicating the law and how it is being then digested subsequently. So I was also interested to ask about this concept. If we can just briefly.
But I think there is absolutely a connection there, and I think if I was to boil down like the whole project to sort of one basic concept, it's that it's accepted in translation theory and translation studies that translation can only ever be an approximation of sorts for lots of different reasons. A very good approximation, but it can only ever be an approximation. Yet, EU law, the sort of very foundation and cornerstone of EU law is that it is uniformly applied throughout the member states of the EU, so throughout 27 different legal systems. But that EU law is expressed through translation, and those two things don't sit well together, where the best thing you can produce is just an approximation, and somehow it has to have the same legal effect across 27 different member states. And so my research shows that, by using translation and translation theory as a lens through which to sort of engage in an exploration of how this law is produced, or how this case law is produced, I can show, or I've shown, that it's all fine at the EU level. So at the level of the court itself, there's an awareness of this approximation and everybody knows what is meant. So it's almost as though the meaning is separate from the languages in which it's expressed. So it is this notion that there's an EU meaning to this concept that's expressed in 24 linguistic forms, but the meaning has an EU meaning. Everybody at the EU level understands that. Everybody at the level of the court understands that. But they're not the people applying the law, right? Then that law is expressed through translation to 27 member states and the various courts in those states. And then it's applied in those states. But the people applying the law are not here at the EU level, deeply embedded in the EU language so that they all understand the gist of what's going on. They're relying on the translations that come through, and they're just reading it in their own language and applying it. And so I guess like the project then claims that this notion of, first of all, textual equivalence in the translation of EU law is a legal fiction that we have to buy into in order for EU law to function at all. And also that this notion of the uniform application of EU law throughout the EU is also a legal fiction that we have to buy into in order for the system to function. And so I think like that's probably the take-home message of it, and the importance of looking at translation. And what I really want to do is to just get lawyers to think about language and to think about the fact that this is a translation for the most part, that they're looking at. They're not, those that are applying the law at a member state level are not always aware that what they're looking has gone through many permutations of translation.
Emilia, I am willing to fight you for this last question.
I had at least two more.
Yeah, I have time.
But I guess that the conversation around language and the conversation about interpretation is really rooted in a certain shared meaning. So when we talk about a lot of the studies on interpretation, discuss different cultural backgrounds, which then affect the translation of text and the shared understanding between cultures. And I wonder with law, whether we can interpret it almost differently to literary text, or whether there is a merit to thinking about it as a different category of within those linguistics and within the interpretation. And precisely because there is a shared set and shared background of civil law, where certain concepts stem roughly from the same framework. So, depending on how far we want to go, if we go back all the way to Roman law, there are certain concepts that certainly grew out of the same tradition. And they are in a way understood uniformly as a schema that everybody operates on. But I wonder if there is a merit to exploring this space almost separately from the studies that have been done in the context of, literary text or texts that don't have not necessarily have a professional purpose or an official administrative purpose because of the existence of this shared sense of meaning.
So there are scholars in translation studies that argue that law should be viewed as what they call like a specialized language. So in the same way as, you know, translation, medicine, or the hard sciences have a, you know, there's a real life thing there that everybody has experienced, and so law traditionally was considered part of either it's called language for special purposes or a specialized language, and it was kind of lumped in with medical translation, engineering, you know, sort of hard sciences. And the idea was that there is this shared concept. There's a shared understanding of what's going on, and so the translation should be relatively straightforward. But that then in the late 1990s or 1998, I think, Susan Sarchevich wrote a book called A New Theory of Legal Translation, which really changed the face of how we understand legal translation now. And with legal translation, it's about ensuring the legal effect stays the same. So there's two ways of approaching legal translation. There's legal translation, the majority of legal translation is where you're looking at the translation of, say, a contract from one language into another. We all, you know, sign our iTunes contracts, or, you know, whatever we're doing. And, you know, if you're reading those in French, you read them. I don't know if anyone ever reads them, but you read your contract in French. It has originated in California in English. It's been translated into French. And the object of that translation is that you, the user, can understand what's going on. But the legal effect sits with the English original, right? It never has to have legal effect in French. It sits with the English original. But the problem with supranational law, such as we have in the EU, is that each language is equally authentic, and EU legislation, in theory, has to have the same legal effect in 24 languages in 27 different member states. So certainly there are broad concepts that are similar and have similar foundations that we can understand easily, and make translation, you know, of law easy in that sense. But in terms of then, you know, getting down onto the ground and thinking about how that law is going to be applied, it becomes very tricky then, because it's almost impossible to ensure that a translated text will have the exact same legal effect as the original text in a different country. Do you understand what I mean?
Yeah, absolutely.
Yeah, so I guess the answer is yes and no to that to that question. But Susan Sarchevich's book is excellent.
Being again mindful of time, perhaps with my two questions. One, I can kind of turn into more of a reflection, and if you can chip in if you think I'm right or wrong, that would be great. So the concept of third space of legal translation was the most philosophically inspiring idea to me personally as a philosopher. What captured my attention in particular was this working of translation as a movement in between. Mm-hmm. Iris Murdoch, in The Sovereignty of Goods, once said that it is not singular, isolated acts of will that matter. Meaning is created through what happens in between. Mm-hmm. What we are as when we are constituted as human beings. What really matters is what happens in between. And that seems to be something that emerges in the concept of translation, or the concept of third space, that the meaning, communication really happens, and not in those singular, isolated moments of declarations, let's say, of handing down a judgment, for example, but what happens in between and beyond in subsequent interpretations of the text that is before us, and then everything that happens before the text is being handed down. So meaning is not something that leaps off the page. Instead, it's to use Stanley Fish's expression. Instead, it's something that is being created in between. Can you reflect briefly on the in-betweenness?
The in-betweenness. I love the in-betweenness, and I love this. I love that concept of a third space. And so I guess if we think about a translator and what a translator does, historically, and probably often people still think this way, that it's about building a bridge from one text to another, right? To reflecting what's happening in text A to what's happening in text B, and it's this bridge. And this theory of a third space in translation, legal or otherwise, is about, well, it's not really a bridge. It's not that the translator is there building this bridge from two static texts from one to another. It's about the translator is existing in this in-between space where two cultures are coming together. And the translator's job is to sort of flit between the two and create something new in the middle. And so in translation studies, this concept of a third space came from work done on hybrid texts. So on people doing work and saying, well, you can always identify a translation because it has elements of the source text and the source culture in it, and yet it's expressed somehow in the language of the target text and the target culture, and it's this hybrid text, and you can identify what a translation is because of its hybridity. And then translation theorists such as Anthony Pym said, well, this hybrid texts are really just a step towards the development of a new language or something new. And then I think a more satisfactory way of understanding what's happening with this hybridity is this notion of a third space, that there is this sort of amorphous space in between these two cultures, and the translator's job is to navigate that space and to create something new from it. And in the paper that I wrote with Eddie Clay that you're talking about there, we were asked to consider whether this theory of a third space in translation would be applicable to what's going on at the European Court of Justice, and we concluded that it wasn't satisfactory, and that the theory perhaps could be amended or moved forward in such a way, because the translation that's happening at the Court of Justice is happening in a very confined, there are very confined, boundaried, performative rules about how that translation is carried out. So it's not quite as amorphous and vague or free-flowing as the original theory of a third space in translation would imply.
Could I just conclude with one practical experience of you, or a question about your practical experience of conducting research and interviews? Only about a week ago at Newcastle, we had this event which was called Beyond the Bench, which was essentially exploring empirical studies outside of things that happen outside of the court, and how judges actually arrive at their decisions, what they think. And an observation was made that as a researcher, you must be careful what you wish for, because you will be asking for permissions to access sensitive data or to interview judges, but that brings a certain responsibility with it. have you ever been in a situation where you regretted, oh my God, what the hell did I got myself into? How am I going to handle those data? Or maybe where you had to back, no longer pursue the certain course of action because there was certain obstacles that made it more difficult. So that's more a kind of practical researcher question. If you ever came across a situation where you wished you never got yourself there.
It's a good question. There are plenty of situations where I wished I hadn't got myself into it. You know, when you write a grant application, you promise the world on a plate, and then you get the grant and you're like, oh God, now I have to do it. So I've been in that situation plenty of times. But I was in the unfortunate position that I worked within the EU institutions before I became an academic. So I had access from very early on in my career, just because I knew the people who worked there. When I was doing my PhD, I mean, people thought I still worked at the court, mainly. Like, it's a big institution. I don't think half of the people I spoke to realized I'd left. And then of course, I'm in a fortunate position where all the people that I was friendly with and who I worked with at the court, you know, continued their career in the EU institutions and then became gatekeepers themselves. And so the access on that level, I've just been very lucky with regard to that. But I did have an experience with the bigger project. So I did some initial interviews in the project with judges and advocates general, and then I had various postdoctoral researchers working for me. And, you know, I couldn't go and do all the interviews myself. So part of their job was to do some interviews with some of these postdocs. And that was a really interesting and tricky thing, because we found that a lot of the people at the court and at the European Commission and Parliament were very willing to talk to me. And this was before Zoom had taken off, you know, so it was all in-person stuff, and I just couldn't do it all. But they were not willing to talk to the postdocs. And so that became just really tedious, because I was, instead of delegating this work, I was having to jump in and like explain and plead, and it ended up more work for me. And then we found a similar phenomenon happening when they actually went to do the interviews, that they weren't getting the data in the same way, that the people being interviewed weren't speaking as freely to the postdocs as they would have to me. Now, I don't know what, like, there's lots of reasons for that. I mean, there's the fact that I'm known to people. There's the fact that, you know, some of these people might have egos and they prefer to speak to a professor than to a postdoc, who are you know, going to be better at it than me anyway. I found that really tricky. And at that point, I remember thinking, why did I don't want to do these interviews. I'm exhausted. So I found that hard. And then the physical exhaustion of interviews, I have now learned in terms of scheduling them, just from a practical point of view, that they really take a lot out of you. It is just chatting on one level, but it is physically exhausting. And, you know, you're staying in like some cheap hotel, and it's not pleasant sometimes from a physical point of view. So I've learned that, to schedule fewer interviews in a day and more downtime is really important, because there was a point where I was doing a lot of interviews and really just feeling very resentful by the time the evening came, and it was a wet Luxembourg winter's evening, and I was exhausted from a day of talking to whoever. And I hadn't anticipated that, so that would be another time, but I kind of thought,
so that's almost the answer to our very final question, which we're going to ask in a minute, about one thing that no one talks about in academia, is the wet winters and bad hotels in Luxembourg. But maybe we could move on, because we're mindful of time. We could move on to the final 5 questions, regretfully, because we could probably continue this conversation into late hours of a Friday afternoon. But who or what was your biggest inspiration in your career?
So these questions I just thought were really good, really great questions. And I'm always interested in hearing other people's answers to these, but then answering them myself becomes very tricky. So my biggest inspiration in my career, my PhD supervisor, as well, two PhD supervisors, one was John Morrison, who's a lawyer, and the other was Robert Harmson, who's a political scientist. And Robert was a huge inspiration in my career. I was very lucky to just happen to be allocated to him, the way that the funding worked. But there's been so many people who've been an inspiration to me. I work currently with a huge number of really inspirational women. And you know, really just, there's too many to name. So then I started thinking about, well, what is it that's so inspirational in my career rather than a who? And actually the thing that inspires me about all of the people who've been an inspiration in my career is kindness. Like, that is the thread that runs through it. So I think the answer to that is it's a what. And the inspiration to me is where people are kind and generous with their knowledge. That has been very inspirational in my career, and I try to sort of emulate that as much as I can in my own career.
Brilliant.
Kindness will be the answer.
Brilliant. What do you wish you could tell your graduate student self other than don't give up on swimming?
Yeah, I would tell my graduate student self to really enjoy that period where you only have one project. You know, that period where you're working on your PhD and that's the main thing that you're doing. I don't think I appreciated that so much. Someone gave me that advice while I was doing my PhD, and I was like, oh, but I didn't take it on board, you know. And now, you know, as you move through your career, and you know, the responsibilities increase and the number of projects on the go at the one time increases, and you've got your like teaching and your admin and everything on top of that. You know, I really think, yeah, really taking the time to enjoy that, just having one thing, and also that most people are winging it most of the time. It took me a long time to become confident in various aspects of academic life. And yeah, to just reassure them that most people are winging it.
I think that's something that we should all frame.
Yeah.
Above our desks. Just wing it.
Yeah.
If you could read only one book for the rest of your life, what would it be?
I bet everybody loves this question. There
was a surprising uniformity in answering this one.
How can you pick one book? So if I'm only allowed one book for the rest of my life, I would choose a poetry anthology, probably by there's a poet I really love called Nikita Gill, who writes feminist poetry, beautiful work. She's a number of anthologies. She's got one called The Girl and the Goddess, Fierce Fairy Tales. She's got a new young adult book out now called These Are the Words. So I would choose one of her poetry anthologies, and the reason for that is sort of the great books that I've read work-wise, I will remember the bits that I liked about them. You know, they'll stick with me, so I won't need them with me, right? If I'm on a desert island, or I've only allowed one book for the rest of my life. And then fiction books, which I love, you know, again, I could probably rewrite them from my memory, and I'd be happy enough with that. But I think poetry for me sparks creativity. And if I had a big fat book of poetry that I really loved, you know, you could dip in and out of it, you get something new each time, and it might spark creativity to you to write your own stuff. And that would be the reason I would choose, one of Nikita Gill's poetry books.
If you had not been an academic, what alternative career would you have chosen?
God, so many. I would probably have written
Olympic swimmer, obviously.
No, God, can you imagine? No, I'm nowhere near that. I didn't even swim that much when I went to university. I discovered like drinking boys and The swimming soon went out the window. I probably would have written children's books. Yeah, I mean, maybe I'll still write children's books, who knows? But yeah, I think I would really enjoy that.
Somebody needs to write a book explaining the legal system to children.
Maybe that
will be you.
Yeah, maybe.
Finish this sentence. One thing no one talks about in academia is
money. It's not transparent. Like, what people earn is not transparent. And one of the most powerful conversations I've had in my academic career was with a colleague, where we shared what we earn. And it just, I really think that is an important thing to understand where you sit in terms of what other people are being remunerated at. And I think that one of the most problematic things in academia, and I think this is true in the UK and beyond, one of the most problematic things is this notion that it's a vocation of some kind. I think convincing people that what they do for a living is a vocation is one of the greatest forms of gaslighting that there is. And I think it's really problematic, because it's not a vocation. Yes, we are privileged. You know, I love what I do, and I'm 100% in the right place for me right now. And I'm really privileged to do something that I love so much, but it's a job at the end of the day. And, you know, and I think that is something I'd really like to see addressed more. So more conversations about money. Nobody talks about it.
That's amazing.
Well, except of the unions,
right? Yeah. There's not enough of it.
And unfortunately, we are all in that position now, that world is not.
It's in, you know, in the UK you have these bands, right? You have you know, bands and ladders, and you know, there's points, whatever point on the scale that you're at, it seems transparent from the outside.
Mm-hmm.
But the thing is, you don't know what band somebody is on, right? So you don't know where you sit. You know what you get, but you don't know how that compares to other professors or other senior lecturers or other lecturers at your institution, at your level. Because that's the bit that's not transparent. And you know, to compare it with, say, the EU institutions, everybody knows what band somebody is on, so it's very transparent, and it's, I don't know, you have more power somehow in terms of understanding where you sit or where you want to get to and why, you know. Yeah, I think conversations about money would be good.
Well, thank you so much. This was incredibly insightful conversation in all sorts of respects. I really hope we could invite you to Newcastle at some point.
Happily,
to speak to our EU students, to speak to our research students, and to speak to the unions.
To the unions now. You don't need to speak to the unions. They're fine.
So if this conversation goes viral because of dragging the unions into it, that's amazing.
But thank you so much once again. It was great to have you.
No, thank you. It was lovely. Thank you again for the invite. I've really enjoyed the conversation, and it's really lovely to talk to someone who's read your work. That's not something that happens a lot as you move through your career. So that's been very nice. Thank you.
Thank you very much. On that positive note, let's wrap up. Hi, it's Aleksandra here. Thank you for listening. We hope you enjoyed this episode. If you like our project, have any questions, or would like to recommend a guest or a topic, drop us a line on just.theory.project@gmail.com. This season was made possible with the generous funding of Newcastle University. If you like, you can buy us a coffee. Your support will enable us to continue our work. Just Theory, changing the face of legal theory.